property, whether the courts below can reach to the conclusion that the land in Khata number 82 was not the self-acquired property of the record which
liberty may be given to raise the other.
liberty is given to formulate another question.
Because we don't know at the time of hearing might not still be hearing.
Second number 33, second appeal 470 of 16.
Lordship in this break one of there is a reason, Lordship, because we are on to substantial question of law, Lordship. That is our main contention in this case, Lordship. And Lordship, that is substantial question of law that has been claimed. The first one is whether the courts below have were right in the plaintiff's suit when the description of the property sold to the plaintiff was contradictory to the earlier release executed by the vendor. And the second one is whether, in view of the undisputed fact that the Amarbai was the owner of 28.5 decimal equivalent to 70 hectares and 3 hectares, 35 square feet of land, whether he can execute a sale deed of 4 hectares and 4 hectares of land after selling after selling 70 hectares. So, because Your Lordship, there is a calculation that has to be done, and I want to be exact in that calculation, Your Lordship. That's why I need some more time to prepare on that. I am ready with the facts, Your Lordship, but for the calculation I need some.
Another request made to the council for the appointment discussion.
Actually.
Serial number 34, second appeal 478 of 16.
My Lord, this appeal by the defendant against application of the trial court judgment. Plaintiff respondent had filed the suit for partition.
Partition was allowed.
Partition was allowed on the pretext that कि 2005 में amendment हो गया है और जो कॉमन एंसेस्टर हैं उन्होंने पार्टीशन नहीं किया है, इसलिए पार्टीशन कर।
There was no previous partition.
यूनिवर्सिटी में see the innovation table that is not disputed. जो ये अपीलेट कोर्ट के जजमेंट में है यूनिवर्सिटी में पेज 27 this is not disputed.
So the plaintiffs are from Dukni.
नहीं, दुगनी और ये दो इनकी डॉटर्स हैं, मुकुंद हजाम की और तनु इज सेकंड सन फ्रॉम सेकंड वाइफ. खुदवा हजाम एंड दुगनी देवी, these two are daughters from the first wife of Mukund Hajam, and Tanu is from second wife. Disputed between these two branches. Mukund Hajam died in the year 1954. This is the finding of the appellate court.
Yes.
So, my submission is that before coming into this 1956 Act,
Yes.
the law was that girls and female cannot inherit. Entire property went to the second surviving wife and to his son. Limited inheritance was subsequently again transferred to the son Tanu. This is how I became, and we are the descendant from this branch.
What is the effect of the amendment?
Amendment है कि जो living daughters of living co-personality will have equal rights. Living daughters of living co-personality. When this co-personality died, this is the finding of the appellate court as well.
Yes.
लेकिन उन्होंने जो है जजमेंट को एंटायर फाइंडिंग इज इन माय फेवर, लेकिन उन्होंने कह दिया देयरफॉर आई एम नॉट इंक्लाइंड टू इंटरप्रेट दिस उन्होंने कह दिया कि सेक्शन 6 भी नहीं लागू होगा क्योंकि जो ये 1956 के पहले ही ये मुकुंद हज्जाम की डेथ हो गई थी, दिस फाइंडिंग तो सेक्शन 6 विल नॉट अप्लाई और देयरफॉर आई एम नॉट इंटरफेयरिंग इन दैट। और जो लंदन ट्रायल कोर्ट है उन्होंने फाइंडिंग दिया है कि ये 2005 में अमेंडमेंट हो गया है, देयरफॉर ईच ब्रांच विल गेट इक्वल शेयर। और उन्होंने कह दिया कि मुकुंद हज्जाम की जो है 2 बेटियां हैं और 1 बेटा है, दे विल गेट इक्वल शेयर। लेकिन ये इन्होंने ये नहीं लिया लंदन ट्रायल कोर्ट ने कि सर्वाइविंग डॉटर्स ऑफ सर्वाइविंग को पार्टनर होना चाहिए, वेयर मुकुंद हज्जाम वाज नॉट सर्वाइविंग, वन ऑफ द डॉटर हैज आल्सो डाइड एज वेल। रुक्मिणी देवी की डेथ हो गई थी उनके।
What is the amendment?
अमेंडमेंट
Which section?
evolution of interest in co-personal property. This was substituted. Subclause A of subclause 1 states, by birth, daughter of a co-partner shall by birth become a co-partner in her own right in the same manner as the son.
Here, this
An explanation of subclause 3 states, for the purposes of this subsection, the interest of Hindu Mitakshara co-partner shall be deemed to be the share in the property that would have been allotted to him if a partition of the property had taken place immediately before the death, irrespective of whether he was entitled to claim partition or not. My submission is कि appellate court ने entire thing हमारे फेवर में दिया है, अगर कुछ जजमेंट के पढ़े और they have not come forward to challenge it, and I am admitting it. ये सारी फाइंडिंग उन्होंने दिया है कि सेक्शन 6 का जो अमेंडमेंट है दिस विल नॉट अप्लाई इन दिस केस। ये भी उन्होंने लर्निंग ट्रायल कोर्ट इज रॉन्ग ऑन दिस पार्ट। That is running page 32.
yes,
May I? The law settled by the Honorable Supreme Court in Prakash and others, Kulavati and others, AIR 2016, Supreme Court 769. It is clear that rights under Hindu Succession Amendment Act 2005 are applicable to living daughters of living co-partner as on 9 September 2005, irrespective when such daughters are born. So it is clear that in the present suit, Hindu Succession Amendment Act 2005 is not applicable.
how?
Because the co-partner was not surviving at the time, and daughters were one of the daughter was also not surviving at the time of
Who are not surviving?
रुक्मिणी देवी जो क्लेम कर रहे हैं कि 2/3 शेयर होना चाहिए मुकुंद हजाम का, 2/3 उनकी फर्स्ट वाइफ से जो 2 डॉक्टर हैं उनको 2/3 शेयर जाएगा और 1/3 will go to the second wife.
Bring the judgment. I think thereafter another judgment is there. Thereafter another judgment is there.
Vinita Sharma कैसे बची उसका?
Yes,
Vinita Sharma versus Rakesh Sharma, the Honorable Apex Court has settled the legal position.
yes. Vinita Sharma. Which says it will be read that it was in the act since 1956. Most probably, if I am not wrong.
Second part of the judgment is कि ये जो है मुकुंद शर्मा died before 1956. This is the finding of the appellate court. इसी के नेक्स्ट इसी पैराग्राफ में आ गया है।
Mukund Sharma died before 1956.
Yes, yes मैडम। और उस समय डॉक्टर्स का शेयर नहीं होता था। इसी में I will be permitted to read.
Where is that finding?
In the middle of the same paragraph, the Hindu Succession Act 1956 Act came into force.
Where are you reading?
I may be permitted to read in continuity.
Yes.
Running page 32.
Yes.
Hindu Succession Amendment Act 2005 is not applicable. The claim of the appellant is that after death of Mukund Hazam, notional partition should be presumed and the shares of the heir should be allotted as per Hindu Succession Act 1956. The Hindu Succession Act 1956 Act came into force on 17 June 1956. The plaintiff of the suit stated that Mukund Hazam died in the year 1974-75 and Exhibit 1 gave a presumption that Mukund Hazam was alive till 16/8/1954. This presumption has not been rebutted, but it has not been brought that he was alive on or after 17/6/1956. The succession opens out on the date of death of the rights of the heirs gets crystallized even if partition was meets bounds does not take place. Section 6(1) of the Hindu Succession Act 1956 confers right of co-personal on a daughter only from the commencement of the date and not from any period prior to that. The explanation suggests that to be rule of evidence, the parties have failed to establish that Mukund Hazam was alive on or after implementation of Hindu Succession Act 1956. In the case of Emma versus Virappan, AIR 1966, it was held that express language of Section 6 applies only to co-personal property of male Hindu holder who dies after the commencement of the act.
Is it your case? You are the defendant.
Yes,
Is it your case that he died before the commencement
yes,
of the?
I have said in my WL that he died in 1947.
And they said in 1975.
सर उन्होंने कुछ नहीं कहा, they are silent on this point. लेकिन एविडेंस में ड्यूरिंग
The plaintiff of the suit stated that Mukund Hazam died in
हाँ, तो
1976.
इन्होंने अपने प्लेट में कब कुछ भी नहीं कहा कि कब डेथ हुई, लेकिन एविडेंस में उनका एक स्टेटमेंट आया कि 74-75 में प्लेट में दे आर साइलेंट कि उनका नाम भी नहीं मालूम है.
And as per you, he died when?
1947. तो उन्होंने एक
Exhibit 1.
1854 का डीड है.
That bears his signature.
ये डिस्प्यूट करते हैं हम, लेकिन इवन इन प्रिज्यूमिंग दैट कि 54 का उनका था, वो 56 के पहले ही है और कोई उनका एग्जिबिट नहीं है.
It is the case of the plaintiff that he died on 1974-75.
No, this is not their case. They are silent on this point.
Okay, they are silent. Now you have brought a case that he died before commencement of the Hindu succession.
Yes.
What proof you have brought?
One of the learned appellate court has also held that he died before commencement of that.
No.
And the other side is not.
This finding is absolutely wrong. It says the parties are failed to establish that Mukund Hazam was alive on or after implementation of the Hindu succession.
Okay.
It's get well with it. Get it? Because this will be an issue.
प्लेट में किसी की डेथ की बात
Or
नहीं.
for the government records. Government records.
My one IA is pending.
Ready for?
Stay of execution proceeding.
What is the stage?
वो execution चल रहा है.
What is the stage?
वो फाइनल डिग्री हो गया. उसमें अपीयरों की शोकास फाइल किया हम लोगों ने.
Show us right here.
जी.
It takes some time by that government record will come.
Video number 35, second appeal 517.
In this case, I was paying for not paid. My senior will, in the 7th class, will assist your lordship. My senior will assist your
Where
lordship.
is he?
Lordship in court number 4, your lordship.
Everyone is in court number 4.
Lordship, there is a DB mat, an IE mat that has been fixed, your lordship.
So only for attending one court and
But
all the other courts will say wait for it. Sorry. Tell him to make alternative arrangement.
just not
Since last 2 weeks I am hearing that he is in court number 4, court number 4. Tell him to release all his cases in which he is in other courts. Tell him to make alternative arrangements.
Lordship, it may be taken up next week any day, Lordship.
What is the suit? Or what was the suit for? What was the read in the suit?
Lordship, it pertains to land, Lordship, that we claimed, we had acquired the plaintiffs here, the appellants here are Lordship, plaintiff, Lordship. We claimed that the land was transferred to us by registered sale deed. Thereafter, we were enjoying the possession, Your Lordship, and we went paying the rents. Subsequently, in the year 2006, if I remember correctly, Lordship, in the year 2006, Halka Karamchari informed us that we are due to the judgment passed in title suit number
Yes.
37 of 2002, that the right of the said land has been passed on to the defendants, Lordship, principal defendants, and hence that we are not. So we appeared to got the reports of title suit number 37 of 2002, Your Lordship. The defendant claimed their interest in the land, Your Lordship, by way of agreement to sale dated of the year 1976, Your Lordship. That agreement was not registered, Your Lordship. It is an unregistered document, Your Lordship, and he claims, and that has the title suit number 37 of 2002, Your Lordship. He has filed for the specific performance. He has filed the specific after the lapse of more than 26 years. That was also barred, Your Lordship. Never during the lifetime of the person from whom they claim that the agreement to sale was made, Your Lordship. They filed any application for specific performance. After her death, they waited another 2 to 3 years for the death of her sons, Your Lordship, and thereafter they have filed an application for specific performance of an alleged agreement to sale, Your Lordship, that they claim that the person had executed in the year 1976, Your Lordship. There is no explanation as to what prevented them from filing the same on any earlier occasion, Your Lordship.
Tell him to appear on the next date. If he doesn't appear, we'll dismiss this.
I will assist Your Lordship.
Yes, then you assist him, or you should get an alternative.
Lordship.
Next week on the list.
Much obliged.
Appeal number 36, second appeal, 124 of 19.
Yes.
Lordship, this is a second appeal and it started as an eviction suit. We've been unsuccessful in the original stage as well as the first appellate stage. And now we're at the second appeal stage, where there are certain issues which I think bring to the attention of the court which have been missed, on account of which the ruling has not gone enough.
The suit was filed
Suit was filed
on the grounds.
on the ground of default. On the ground of default. That's where I'd like to start off and draw your attention to the judgment as the eviction suit judgment, which accuses us of a default of default in rent payment. The allegation is that we've not paid rent for a period for the month of 2013, January, February, March, for which we owe, and that itself has become the ground for our eviction. going into the larger issue of the suit, is there are several other episodes which have led to this point. What has happened is the original landlord has wanted us evicted from way back in the year 89. 89 was when there was a title suit between the father of the plaintiff and the defendant. What has happened in that title suit during the title suit was initiated and it led to a stay order, which was by which led to a stay order as well as a compromise. Now this question of whether there is a compromise with money is involved, that is being raised, or the defendant simply challenges the fact that there was no such title suit or exchange of money or any compromise. Because if he does that, then he's really bound, and that really goes to the heart of the matter. It really strikes his position. Our contention is that during this period between the title suit leading to the point of 2012 December, their allegation is straight that you have paid rent. It must be presumed. It must be presumed that till December 2012 rent has been paid, because now they've raised an issue that for the month of 2013, January, February, March, which has become the ground of eviction, we've not paid rent. And this is if we go by the JBC old act, that is the 2000 act, based on which they want us evicted. Our contention is simply based on this, that you're not accusing us of default in the past beyond the period of prior to the period of 2012, 11, or any period starting from title suit of 89. Another thing, one of the crucial issues over here is the compromise. There was a compromise struck between both the parties, and there was an amount paid. It is our contention that we paid 50,000 of one installment as a financial aid, and the second installment, that was another 50,000, that was paid as a security deposit. That was supposed to, in a way, act as rent already paid for the period starting in 2013. So the allegation again that in 2013 we have not paid rent.
Where is the agreement to that extent?
Lordship, I really
That rent was paid in advance.
Lordship, that compromise, there are prosecution witnesses there are two prosecution witnesses, they're unable to testify to that fact. There are defense witnesses. What they've done is they partially, they say they have knowledge of this fact, but they cannot completely certify that they know completely that there is an existence or document of such a nature. And again and again, this is being disregarded. The trial court's observation is simply that there is no documentary evidence, therefore we will not lend any weight to this claim. And you are supposed to say, the defense witness who claim to have knowledge of this compromise are completely being disregarded.
What is the documentary proof that you have paid 1 lakh rupees?
Lordship, there is none. There is none. It's prosecution defense witness himself who's the defendant here. No, who's the plaintiff here. He himself said there is no documentary evidence, but this is by way of an informal transaction. Say by way of a donation. Every time you make a payment, you don't get a receipt, or every time there is no acknowledgement of that. I may be allowed to further draw an analogy on this point, Lordship. The salami payment under Section 6 under the JBC Act is of a similar nature. It's a unilateral gift. This may be viewed as that.
there has to be a specific agreement in the rent. This amount is being advanced, it has to be adjusted on month to month. There has to be a specific agreement. If you want to take this defense, this is your defense? Yes, Mr. Gupta?
Yes, yes.
This
That
is
is
your
the
defense?
That is the difference.
So if that be the defense, there has to be a specific agreement.
And Your Lordship, I must say that concurrently it has been held that
Yes,
yes,
that you say that it is admitted, there is no proof.
Yes, ma'am.
but if he can show from defense witness that defense may plaintiff's own witnesses that they have admitted payment, then
Plaintiff witness doesn't say anything.
Payment is nothing. Payment coupled with the fact that they should be adjusted on the monthly rent.
Another, may I?
There is nothing.
There is, Lordship.
What is it?
he may be allowed.
Yes.
He is better prepared than me.
Yes.
Lordship, the tenancy, nowhere in its original suit as well as in the appeal does it recognize the fact that this is a commercial tenancy. They had an entity. It was a commercial entity which went by the name of petition. Haribaksh Matadi. Haribaksh Matadi. This was a commercial entity. Nowhere has this been recognized. And the rent receipt, which was always cut, was cut on the name of Haribaksh Matadi, thereby creating a distinction between the owner, functionary, and the commercial entity, that is Haribaksh Matadi.
What is the nature of entity of the Sariyos Madhuri?
It's a commercial entity.
What do you mean by commercial?
Commercial entity has a separate juristic existence. And with respect to the 50,000 and 50,000 payment,
If it is a proprietary business,
then again it would raise a question of non-joinder and misjoinder of parties.
you have to prove what is it. You are taking this ground. The suit was filed against whom?
Suit was filed against us, not. That's where we raised the issue that Haribaksh Matadi is a separate entity altogether, and because
What is the nature of that entity?
it
It's a
is
partnership firm, it's a proprietorship business or a publicly limited company, what is it?
Lordship, but that has not been specified in any of the.
You have to specify it.
That is an issue we had to raise because that was
not
not
raised. You have not raised.
we had the commercial code the lower courts did not find it worth considering.
It is a proprietorship form, my lord. It has been mentioned in the decree in original suit. Rajkumar Agarwal, son of so and so, proprietor of Haribaksh Matadi. It is a proprietorship.
Come to running page 24. Issue number 4.
Regarding issue number
It is found that the defendant, the accused, has agreed to the fact that he used to run the same shop in the name of Haribaksh Matadi. Earlier it was written that prior to that your father used to run the shop and after his death you inherited the shop. And the plaintiff used to provide rent receipt to the defendant in the Haribaksh Matadi. That means I find that in simplest value default of the payment limit will be not verified. So that means if it is a proprietorship firm, you admit that then the fact that the relationship of landlord tenant is admitted. Now the question is default, and it has been held that it's a proprietorship firm. Proprietor of Haribaksh Mata. Then it's a proprietor. Where is the point of default discussed?
The point of default is discussed on
Issue number 6, my lord.
See,
Trial court
by
judgment.
taking a defense, then you had paid 1 lakh rupees into installment, 50,000. That had to be adjusted. You admit that you have not paid monthly rent.
not
It's an admission.
No, absolutely not.
Then
Then they would have accused us of not paying rent for the entire period between
it is not
89
necessary.
and 2012.
It is not necessary as per the BBC Act. They only have to say you have not paid rent for 2 months, not even consecutive months.
Lordship, may I add
So now, when you take a defense that I had paid him, the landlord, 1 lakh rupees, and that had to be adjusted. So it was being adjusted. That means you have not paid month-to-month rent.
No, Lordship, it may be presumed, it may be simply presumed for the period between 89 title suit, that is point A, and your point B would be December of 2012.
December
And
2012.
If you're talking about rent control is a beneficial legislation, Lordship, it deserves a liberal
So where
interpretation.
did you get it? Is this a beneficiary discussion?
There is a judgment, Lordship, Shobha Agarwal versus Union of India.
Yes. So,
I don't have the citation, I just
that
can I bring it to you, Lordship, in the future?
in future case you will bring a payment. Now tell me what is the further one? They say that rent was not paid from January 2013.
Exactly.
What is your defense to this?
We are under the impression that the money paid already as a part of the settlement would act as rent.
Have you brought any document?
There is no document. There are 4 witnesses, defense witnesses. The prime defense witness being Mr. Agarwal himself. He himself says
Money was granted.
money was.
Does he say that this money was granted in lieu of future rent?
In
No.
specific terms,
No.
no.
You-
It was when
What is
we lend
what is
money, there is a
what
presumption.
is the law of evidence? What is the law of evidence?
Law of
If
evidence.
you plead something, you have to prove it's not the other side. Once you have proved that it was for future rent.
On that issue, Lordship.
So on the point of payment, okay, I accept. That was compromised by paying 1 lakh rupees or something like that. But show me that
By no means can we presume that this is a
there is no
matrix.
question of presumption.
No, Lordship.
What is the question of presumption?
Presumption.
Show me where
When we
is the
pay
scope of
money,
presumption?
it was for something, it was for a very specific purpose.
Show me what
With
is
the
the
expectation that this money will be
Yeah,
returned
that
back.
is your expectation, not the expectation of the plaintiff. Show me.
There is nothing on record.
There is nothing on record.
But the Lordship, it would be, what I'd like to submit is that it was more of an informal transaction. And every informal transaction does not always have to have a record of a transaction taking place.
Then you have to prove specifically.
specifically what is available is being disregarded. That is the defense witness testimony. That's all. Because of a document, I understand the weight of a documentary evidence is far more, but the defense witness's testimony is being completely disregarded.
As per you, this compromise is in a suit? In a suit?
In the title suit, which ended with a status.
What happened to the title suit?
There is nothing on record of that sort. It simply says it ended as there was a ruling for maintaining status quo, and after that the parties entered into informal compromise, which is undocumented. One of the defense witnesses states explicitly that
So just the suit was compromised?
suit. It doesn't
It was
say that.
compromised?
It does not say
It
that.
is your case.
Yes, no.
You have to say it, you cannot say it is not stated.
There is
The
nothing.
suit was compromised?
Yes, no.
What happens when the suit is compromised?
Both the parties get what they would want.
For some of that has to be a compromise decree. Where is the compromise decree?
Compromise decree, yes, no.
You have
It
brought
is
it on
of
record.
an informal nature. That is
There is nothing called informal, Mr. President.
logic. I'll point out what the defense witness has stated.
Yes.
He testifies to the fact that there is a document, there is compromise, which is a record of this, compromise. But none of the parties have signed it.
Why? Have you brought it?
I have nothing.
You have not brought it on record also.
I am simply relying on the defense testimony.
So then, only on oral evidence. Only on the basis of oral evidence.
Something in place of nothing.
Okay. Heard the counsel for the afterwards. Yes, Surya.
Yes, my lord. There is concurrent finding of acts, my lord. In both the courts below are rightly decided.
Heard the counsel for the afterwards and heard the counsel for the response. This appeal under section 100 of the CPC is directed against the concurrent finding of facts in eviction suit number 17 of 2013, thereafter civil appeal number 44 of 2018. The plaintiff respondents filed a plate registered as eviction suit number 17 of 2013. Claim therein to evict the appellant defendant from the suit premises on the ground of defaults. The suit premises is a shop room having an area of how much?
15
by 12.
12.
15 by 12.
12.
180 square feet. It is the case of the plaintiff that the defendants, who is the proprietor of Haribaksh Matadi, defaulted in paying rent from January 2013 to the plaintiff. Thus made him liable to be evicted from the premises. The defendants appeared and objected to such eviction on the ground that earlier a suit was filed by the title suit was filed by the father of the defendants, being 92 of 89, against the mother of the plaintiff seeking permanent injunction, where a direction was given by the court to maintain status quo in respect of the building. It is further case that the same suit was compromised, where the defendant agreed, wherein the defendant, who is the father of the defendant here, agreed to pay rupees 50,000 to the father and grandmother of the plaintiff as financial help to construct the building, and there was an understanding that the same should be adjusted from the month of January 2013 onwards till the same is adjusted. Further, it was agreed that rupees 50,000 was to be paid by way of security deposit, and the same would be refunded to the plaintiff from January 2013. How much? 1 lakh was paid, or 50,000?
1 lakh. 1 lakh.
Only for the purpose of live streaming I'm here.
The case of the defendant is that they have paid the aforesaid amount and thus they were not required to pay any rent till that amount of 1 lakh was adjusted. Next one. On the basis of pleadings, the trial court framed six issues, including the issue of determination of the relationship of landlord and tenant between the parties, and the issue whether the defendant can be said to pay his mortgage. Next slide. The trial court decided issue number 4, that is the question on the relationship of landlord and tenant in favor of the plaintiff landlord. On the point of on the issue of default, the trial court held that rupees 1,000 per month was the rent, and the defendant is a defaulter. The trial court further discarded the contention of the tenant by holding that there is no document in respect of the financial help, nor regarding payment of 2 installments of 50,000 each as paid by the defendant. Though the defendant witness has stated that 1 lakh rupees was paid to the plaintiff's ancestor. The trial court held that the last rent was paid in December 2012 and the rent fell due for 2 months thereafter. Thus the defendant side. Next. The appellate court in considering the evidence concurred with the finding of facts arrived at by the trial court and dismissed the appeal of the tenants. Agreed by the aforesaid judgments, the counsel for the appellant submit that the courts below failed to take into consideration the compromise which has been arrived at between the parties, which clearly suggests that the rent was not to be paid till the amount of rupees 1 lakh was adjusted. So, what was the other point?
Other point is that a sum of rupees 1 lakh was there. Out of that, 50,000 was as security, and
The further submits that the 50,000 rupees over that 1 lakh was security which ought to have been adjusted.
And therefore, there was no default.
Since it is the case that since the eviction suit is premature and no cause of action arose, as neither the advance amount was adjusted nor in the period of adjustment. The amount of advance was adjusted. He submits that the council submits that the landlord plaintiff cannot take benefit of his own wrong by not adjusting the amounts. So he submits that the amount should have been adjusted before approaching the court by filing an eviction suit. Yes. After going through both the judgments, I find that the relationship of landlord and tenant between the parties has been just. The only dispute is whether the appellant defendant can be said to be defaulted. To prove this, to prove the fact that the appellant is not the plaintiff stated that from January 2013, the defendants have not paid rent for 2 months, and thus they are liable to be evicted. So to counter this, the defendants have taken a plea that 50,000 rupees was paid as an advance and 50,000 by security deposits, which ought to have been adjusted from rents, by way of rents, and since the entire amount has not yet been adjusted, they cannot be said to be defaulted. It is an admitted case that there is no document in support of the aforesaid contention. The only material which the defendant is relying upon is the oral evidence of some of the witnesses. Only to the effect that amount of contact was paid. Even if the court agrees that an amount of 1 lakh was paid, but the purpose of paying the exceed amount should have been documented. Further, if the rent is paid in advance, there should be some acknowledgements. There should be a written contract. First, the written contract, because in terms of the section 11 D.
11D is the default.
This is the provision that it should be month to month, and there should be in exception there should be an agreement. In terms of 11D, the payment of rent has to be paid on monthly basis. And a tenant is liable to be evicted if the amount of 2 months rent lawfully paid by the tenant remains due. From him is in arrears by not having been paid within the time fixed by contract. So in absence of a contract, the last day of the following month should be the date by which the rent has to be paid. So that being so, if the tenant wants to take a plea that there was the rent was not due on the next month, or the next due rent would be some other period, there has to be a contract between the parties, either oral or documented. So in this case, there is nothing to suggest that there was an agreement that the rent would be adjusted from the advance amount. The trial court thus held that the defendant is in default. So next slide. The appellate court also independently assessed the evidence and has held that from 2013, January 2013, the defendant has failed to pay the rent and has thus defaulted, and is thus defaulted for 2 months. Full stop. The fact of default has been concurrently held by both the courts, which is essentially a question of facts. Thus, I find no merit in this, and thus there is no point of law to be populated in this appeal. This appeal stands dismissed.
Now, your trial court had formulated altogether 8 issues. Your lordship had declared 6 issues. 8 issues.
On amongst other 2 issues.
Yes.
Which are such.
Obliged.
Serial number 37, second appeal 256 of 19.
Appealed by the plaintiff appellant is suit filed by the plaintiff on the ground of personal necessity and default. Suit was dismissed against appeal was filed. Appeal was also
You fail to prove the personal necessity and default.
personal necessity. The appellate court says that special provision was not invoked. That's why we are
Special provision means
section 14 is the special provision.
it is a composite suit. Where is the question of
Composite suit that
where is the question of special provision?
and that appellate court
Section 14 is only when it is personal
specific
necessity.
only personal necessity.
Only
and
personal necessity.
11(1)(c) is invoked, only then 14 will be possible.
Yes.
For 11(1)(c) and E.
When it is a composite super, even one is seen, there is no question of invoking 14. Where is the finding?
It is the appellate court says at page 9 top
9.
in the page 9 of the appellate court judgment. It is worth to mention here the ground of personal necessity of the plaintiff was not later on raised as
Appellate court.
civil appeal number 160 of 18.
What's it? Yes.
Paragraph 11 name,
Page 9.
page 9 of starts. It is worth to mention here that the ground of personal necessity was not later on raised separate from the record. Personally, there is a separate provision of hearing of the suit that is not adopted.
You have not raised it. You have waived this. Abandoned this.
And second part is the default, February and March 2004. Now, rent when it becomes due and if not paid, it becomes default. 11(1)(d) says that if there is an agreement, if it is not paid within that stipulated date, or if there is no agreement for month to month.
Let us see the trial court judgment.
Page 16, it is the argument of plaintiffs. Counsel of the plaintiff had stated that the eviction suit has been instituted on the ground of default of rent from
The
February.
court has said that he continued paying for money on.
Money order started from 31st May 2004. The 31st May 2004, it can be remitted only for the month of April, up to the last date of the month. March, they cannot cumulatively send to the landlord if it is not earlier remitted by the money order. So March already, admittedly, there is a default. Clubbed together and
So 1 month default between not exact eviction.
in February he says not, there is no printed receipt.
Hence, from the documentary and oral evidence, it is clear the defendant paid rent for the month of February 2004. You paid, and when the plaintiff did not accept the rent and also demanded enhanced rent, the defendant had validly remitted rent for the month of March and April on 31/5/2004. So as a default, they have to continue to remit the rent till month of May 2010, sent by postal money application.
May up to the 31st May, he can send rent for the month of April.
Yes, yes, sir.
March here he cannot send.
So 1 month default.
And February.
No, February said he has paid rent for the month of February.
Paid rent, your lordship says that they say that rent receipts are not printed, so it was not granted. Now your lordship suit section 20 of the Jharkhand Release Rent Eviction Control Act. Tenant making payment of rent entitled to receipt. Every tenant who makes a payment on account of rent to his landlord shall be entitled to obtain forthwith from the landlord a receipt in the prescribed form for the amount of rent paid by him, duly signed by the landlord or his appointed agent. 2 is, if the landlord without reasonable cause fails to deliver the tenant a receipt as required by subsection 1, such landlord shall be liable to fine not exceeding double the amount of the rent so paid to be imposed after summary inquiry by the controller upon a complaint of the agreed party within 3 months from the date of such failure. Now he didn't invoke this jurisdiction. So orally defense that I have paid rent, printed receipt was not there, so he has not granted receipt. It cannot be, he is stopped from raising this point because specific statutory provision is there. Mere oral defense that I have paid, printed receipt was not there, that's why before that they cannot. If they don't invoke section 20 of the Act, then they cannot take a defense that rent receipt was not granted. It has to be granted forthwith.
No, rent receipt, hence from the documentary and oral evidence, it is clear that the defendant paid rent from the month of February 2004. Just tell me.
It is a defense of the defendant that I have paid rent, printed receipt was not there, so receipt was not granted. February not granted, March not granted. He didn't move. Section 20 is there, it has to be granted forthwith. The moment rent is paid, rent receipt has to be granted. If it is not granted, we must complain before the controller that it has not been granted. And if we don't say so, don't do so, then he is stopped from raising this plea that I have paid, receipt was not granted. The statutory provision is that's why included in the Act itself.
Your prayer is that he has defaulted from when?
February 2004, March onward, then February and March it is that on the record, 2 months rent is default.
Let me see LCR. For the